It's
Cool.
New England Take. I'm your host, AJ Kierstead, NHTalkRadio.com. To get the back episodes of the show, and be sure to follow New England Take on Facebook and Twitter. Follow my photography if you feel like following New England Take over on Instagram, too. There's no show content over there, but I might as well plug my Instagram while I'm at it. Excited to be joined today by Michael Dube. He's a visiting assistant professor of law over at UNH Franklin Pierce School of Law. Great guy. I've known him for a couple of years. Welcome to the show.
A couple years is putting it live. I've known you for quite some time, and it's really great to be on your show. Thank you so much for having me.
And for those of you listening on the radio, he's shilling as hard as he possibly can for UNH. He's got the UNH hoodie. He's got the fancy drone virtual background. They got what is Megan giving you over there?
It's all in tribute to you, AJ.
Yeah, another thing for those who are regular listeners, I worked at the university for 12 years, and I left on this at the beginning of the month to work somewhere else. So that's what he references there. But speaking of my new employment, I now work at the New Hampshire Insurance Department, so I'm on all sorts of mailing lists for all sorts of other things than law. But then I happened upon this article by the Insurance Information Institute, known as III, talking about the article is what is third-party litigation funding and how does it affect insurance pricing and affordability. On the face of it, it sounds like a horribly boring topic, but when you actually consider the implications and the case history with something like this, it's huge. I mean, generally speaking, when you're talking about third-party funding, which is outside individuals paying for the plaintiff or the defense or something in a lawsuit. Is this something that's basically happened forever? Or is this the extent of it really expanded over the last 20 or 30 years?
Yeah, I mean, this is something that's been tried forever. Certainly, you can go back to the Middle Ages and find court opinions and find scholarship such as it was on this practice. It used to be called champerty in the old days, and now it's evolved into something called litigation funding. It really exploded, as you allude to, AJ, in the last 20 or 30 years when some entrepreneurs, decided sort of to test the waters and see whether or not this was something that courts were going to allow. And courts, by and large, have allowed it. And it's very quietly, or maybe not so quietly, transform the way litigation happens in the United States, at least to some extent.
I mean, is this partially... See, I can think of two big things that may have spawned this. One is the internet and social media and everything, which we'll dive into a couple cases specific to that most likely, which is now everyone has a voice, so you're just prone to more things getting shared or put out there. And two, maybe, I mean, kind of along the internet lines again, is patents, trademarks, and copyrights are just like globalization's a thing. And you're talking post-World War II especially, it's really expanded probably a lot more than was humanly possible before that time. Are those the two big buckets, or are there other ones that are fairly common?
Yeah, I mean, that's a really interesting question. I think that what has really sort of spawned this proliferation, and this does tie in with the themes that you correctly raise, is really this feeling that folks should have a voice via the court system. This is something that I talk with my first-year civil procedure students about, and this is something that a room full of lawyers with 500 years of practice experience between them talk about on a day-to-day basis, which is, how do we get a meritorious claim before a court? How do we advance a client's voice in court? And look, lawyers are expensive, litigation is expensive, and so the notion of not having meritorious cases die on the vine for want of funding is really, the main thing that's spurring this on. And you're right, certainly, litigation in the year 2022 is certainly, as it was previously, is certainly about having a voice, about telling a story, about bringing the truth to the fore. Many might say, cynics might argue otherwise. But so, yeah, I mean, I think that a lot of this is new, and a lot of it, deals with these universal questions, these sort of age-old questions of how do I pursue justice when justice is expensive?
Yeah, and it kind of, maybe there's another bucket there that I don't know how common necessarily was before the civil rights movement versus post-civil rights movement, but the concept of equal access to justice is like the the key phrase that I heard repeatedly over my tenure over at UNH for communications and such, and hearing former Chief Justice of New Hampshire Supreme Court John Broderick, that was a big cornerstone of what he did in addition to mental health awareness. Like, this is kind of a way for people that maybe didn't have access to decent lawyers outside of the pro bono side of the house to actually be able to have a proper case brought up.
Yeah, I think that's right. I mean, look, we take for granted today contingency fee agreements, but the truth is that contingency fee agreements were of questionable legality until some decades ago. And, attorney advertising was of questionable legality until the Supreme Court addressed that and put it to bed in the 1970s and blessed it on First Amendment grounds. And so a lot of the things that we take for granted now, such as the ability to get into court due to contingency fees, the abilities of attorneys to advertise, and other such things, really have developed in recent times. And, so I think that this is sort of the latest thing that's developing. And it certainly, I don't want to minimize your point in any way, it certainly does have at its heart the notion of, again, cases, really not only cases getting to get into court, but plaintiffs not needing to settle those cases on the cheap, so to speak. I think one of the main arguments advanced in favor of these litigation funding companies, or at least in favor of litigation funding in general, is that previously, even if an attorney would represent a client on a contingency fee basis, that attorney might not have the resources to really shepherd the case through to a conclusion. And there was really only one thing that a client could do in that instance, which was to settle on the cheap. That is to say, to settle the case for less than the fair value of the claim. And litigation funding is it can work as a supplement to contingency fee agreements. It can work as an alternative. But the idea here is that it allows cases not only to be brought, as contingency fee agreements certainly do, but to thrive, and to thrive through the discovery process and potentially to go to trial if that's what it takes for justice to be achieved. Obviously, there are critics who say that litigation funding has led us down a primrose path, and that's not actually what's happening. But in theory, this is certainly part of that sort of the solution to the very vexing question of access to justice.
I think the most interesting aspect of this topic is ethics and the way that plays into where's the line here. Like the most common example of a case I can think of where this sort of concept really came to light was back when I was, good God, I can't remember what year that was. It was around 2010 or so. It was the Gawker case with Hulk Hogan as suing Gawker and primarily being funded by Peter Thiel, right?
Yeah, I believe
Thiel.
So. Yeah,
and Gawker upset Peter Thiel previously for outing him as gay. The whole ethics around that, totally other thing we're not going to dive into right now, because that was a very messy situation, generally speaking, that I think he sued and lost ultimately. And he held a grudge and proceeded to fund Hulk Hogan suing Gawker basically
$10 million.
Yeah, out of business. Like, Univision ended up buying them. I remember, as someone who's in the media, I'm like, why the hell is Univision buying Gawker? It's like, oh, it's because it's an IP that's very useful and is still around ultimately nowadays. It took a long time, but Gawker and Gizmodo and such are still floating around. I mean, the ethical consideration of someone like Peter Thiel, who has no direct connection to this case except for the fact he hates Gawker, is huge. I mean, when you have law students bring up this sort of thing and how they want to handle cases, like, I don't even know where you begin on that.
Yeah, and the other thing that was so interesting about that case was that it was unknown for quite some time that there was any litigation funding going on. And then I believe, if I recall the facts of the case correctly, there was a rumor or some rumors, maybe some reporting that there was some rich individual who was bankrolling or financing Hulk Hogan's case against Gawker. And then ultimately, a major outlet, maybe it was the New York Times, broke the story that it was Peter Thiel that was doing the funding. And it was never very clear whether he was doing so with the intention of obtaining any sort of portion of the proceeds, or whether, in fact, it was solely based upon this grudge that he held against Gawker. But As a result of that, one of the ways that at least some courts have tried to address this ethical issue is, and again, this goes to an issue of civil procedure, is to require parties to disclose at the outset of a case whether or not they are being funded by any, as you correctly put it, disinterested third party, and then to also provide the details of that funding, such as whether or not that third party might have a seat at the table in terms of making any sort of settlement decisions, which they, may or may not. But the District of New Jersey, which is a federal court, was, I believe, the first federal court to actually require every party at the outset of a case that's receiving such funding to disclose it. And I know other state courts have looked at and in certain cases considered implementing that. There is some federal legislation on this topic that hasn't really gone anywhere, but might, as this issue is covered more and more. And yeah, I think that is a very, very interesting ethical issue within all of this, which is, if there's nothing wrong with this, then why not disclose it?
And on the others, another more civil rights, ultimately, when it comes to this, is the whole nature of how the ACLU operates. I mean, they have their own funders that contribute to their operation at the state level or the federal level. They only take cases that they feel they have a role in with their mission as a nonprofit organization, and people don't tend to think of the implications of that. Like, they have their own way of thinking about things also, and their funders are only going to continue funding them if they, in theory, pursue certain sorts of cases. And we can see the kind of shift politically of that organization from decade to decade moves a lot one way or another. But we all tend to think of groups like that as a positive, but still it's the same ethical decision.
Yeah, I think that, across the political spectrum, there are groups that certainly represent folks, plaintiffs and defendants, that whose cases are philosophically aligned with their views. Again, you see that on both ends of the political spectrum. Recently, I believe the Masterpiece Cake Shop case, which came before the Supreme Court, that was a case obviously involving the issue of whether a wedding cake baker, I believe in the state of Colorado, whether their free expression rights were being trampled upon by the state in requiring them to serve a gay couple. And I believe that the plaintiff in that case was represented by, the baker, should I say, was represented by an organization. There's a 303 creative case, which is currently before the Supreme Court, involving the question of whether a website designer should be compelled to design websites for gay and lesbian couples.
With those cases, it's both sides also. It's not just one side is having this sort of big funding. Like, both sides of these are very much, outside groups are involved with how this case is happening.
Yeah, and I think this is what we think about as sort of more traditional litigation funding in terms of legal defense funds or organizations that bring test cases on behalf of certain plaintiffs whose views align with the organization. So you're right to point out that, when we think about litigation funding, it's not just a company that is, providing $5 million to XYZ Corporation to file a breach of contract case. There's Peter Thiel funding the Gawker case. There's obviously legal aid organizations. And certainly there are plaintiffs who need money to get to the point where their case is going to be settled. They might otherwise be happy with the contingency fee arrangement that they have with their clients. I'm talking mainly, of course, about personal injury actions and the like. They may be perfectly happy with the contingency fee arrangement that they have with their clients, with their attorneys, but at the same time, they simply need some money to stave off foreclosure, to stave off an eviction, to feed their children, for perfectly rational reasons to seek this money. And in that case, they often, can seek litigation financing. There are obviously academics and others who say, well, let's look at the amount that ultimately is owed to those financiers. It often is a significant portion of what they ultimately recover. And they, obviously there are ethical questions raised there as well. I don't have any easy answers to those, except to say that they're certainly raised in the context of this discussion.
Do you have any examples of where this sort of funding is either is straight up illegal or has been a problem in the past where, outside from just public outrage, which is the low-hanging fruit discussion of it, but literally there was a line crossed where it was seen as illegal in the civil or criminal side of the House?
Yeah, well, I hope it goes without saying that obviously nothing that every attorney feels compelled to say this, and nothing that I'm saying today is legal advice or anything of the sort. Obviously, if you have legal questions, you should consult with an attorney who's licensed to practice in your jurisdiction. I will say that here in New Hampshire, before answering your question directly, here in New Hampshire, the view, at least among many scholars, is that this has been blessed by the New Hampshire courts for some time. We're the live free or die state. And so New Hampshire hasn't really had a problem with this concept of champerty for some time. There's never been a case, to the best of my knowledge, directly confronting in New Hampshire whether or not litigation financing is okay, or whether or not there could be some sort of defense to a contract involving litigation financing. That I don't believe that issue has been directly addressed, but at the same time, New Hampshire courts have generally appeared pretty, short of a party outright selling their claim and letting somebody else pursue it. The New Hampshire courts have been largely in favor of allowing these arrangements to stand, of these arrangements not violating public policy. And a number of other states, Minnesota, I think, is a great recent example, have blessed these arrangements as well. States that previously held such contracts to be illegal. But there are still some states that don't necessarily look as favorably upon litigation financing. Pennsylvania immediately comes to mind in terms of the closest state to us geographically, of a state that has not gone as far as other states in making it absolutely clear that litigation financing is okay. Obviously it could be challenged in a variety of different contexts. And, Pennsylvania is a state where, I think, merits some investigation were someone to engage in that transaction, perhaps more than other states. But, obviously, again, these companies do their own research, and people engaging in these contracts engage counsel to do the research. But I think that there are, despite the fact that litigation financing is the hot new thing in terms of, in terms of the world of litigation and funding it versus more traditional recourse loans, let's say, I think there are still states, that look at litigation financing with a bit of a jaundiced eye. But here in New England, I don't know that I've seen any state court come out very directly against it, at least to the best of my knowledge.
So about a minute and a half left. I mean, do you think there's a risk, especially as more and more people consider this as a possibility? Will this have a chilling effect, do you think, on so many? There's a million ways to consider the chilling effect. Chilling effect. Talk about it.
Right. You are ready for law school, by the way. I look forward to seeing you next year. No, I look. People in favor of litigation funding says that it has just the opposite. That it gets people into court. It gets potential defendants to be careful because they know that plaintiffs are going to be funded. They're going to have the resources to obtain a fair value for their injuries. And certainly, so I think it's not going to have a chilling effect. I think if anything, it's going to, if not increase litigation, perhaps decrease the amount of cases or number of cases that settle. I don't know that this has been studied empirically yet at this point, but certainly that is a potential. Given the proliferation of litigation funding. But I think if it does have a chilling effect, this may be what finally is something we haven't gotten to touch on, but I'm glad I have this quick opportunity, finally leads to some sort of regulation. This is a largely unregulated field, and it'll be very interesting to see whether or not, as so often happens, some event occurs that causes people to really take notice, and suddenly it's a regulated industry. And that is certainly, a chilling effect on litigation is certainly one possibility.
Yeah, and that's been an interesting thing as I've delved into various cases is, do you want to open that can of worms? And you probably don't, because it's going to be very messy, because there's so many different angles that can be addressed on something like this, and it'll be interesting to see what happens going forward with such things. But excited to be joined today. Thank you so much with you, Professor Michael Dube of UNH Franklin Pierce School of Law. He's a visiting professor there this year, and he's a great addition to that team. law.unh.edu. If you want to learn more about them and apply, please apply. We need that law school open in the States, the only one here. Thanks so much for joining me, Michael.
Thanks so much, AJ.
It's the New England Take. I'm your host, AJ Kierstead, nhtalkradio.com to get the podcast version of the show. New England Take on all your favorite social media platforms and podcast services. I'm your host, AJ Kierstead.